Welcome to Legal Talks Jurisprudence Talk 3. In today's topics, we'll be discussing at right and rem, state decisis, estoppel, liability, obligation, and rule of law. So let us get started with today's session. Let's get started with rights and rem. So rights and rem is also referred as or popularly known as jus, jus and rem. Okay, so basically it is a provision to protect a person's property from the entire world. Okay, so it talks about the very basic natural right which a person possesses on his belongings. Okay, so every person entering into an contract has right in rem. Right in rem in the sense, once you enter into a contract and the contract is materialized, then you possibly become the owner of that particular entity. It is referred as a negative right as it gives the right to any person to be left alone. So in general context, because it shows a sort of possessiveness, it is also referred as a negative right. Okay, so this is one aspect of it. So no other person can interfere with his or her rights. Okay, so it provides total control on the possession of the things, as no one is allowed to interfere in any sort to tingle or to disturb his or her rights. Okay, it is given via the freedom allotted in Article 19 of Indian Constitution with some restrictions. So, for example, Mr. X owns a house and has a right in rem with respect to the house. So nobody can interfere with his ownership. No one can disturb his right in rem. So what it means to say is, like for instance, Mr. X owns a house. So since he owns a house, he is in total control of his house. Okay, how he is going to live in his house is up to him. Okay, as he has right in rem with respect to the house, and no one can dare or no one can interfere with his ownership. Okay, so this is one example of rights in rem. In the similar manner, Mr. Y has a suitcase full of cash. The money belongs to Mr. Y exclusively. So, for instance, let us take a situation where a person named Mr. Y is in possession of a suitcase which is full of cash. So obviously all the money that is there inside the suitcase is the property of Mr. Y and no one can access it. The whole world or anyone cannot take it away. Okay, so it is the whole and sole property of Mr. Y and he holds all the rights on it, or it is the suitcase, it is rights and rem of Mr. Y, and so no one has access to it. They cannot disturb his possession or interfere with his ownership of the money. Okay, so these are the two simple examples to understand what rights in rem is all about. So moving on further, let us see what state decisis is. Basically, state decisis is a provision in law where it talks about a judgment that was issued in the past, a verdict that was issued in the past remains the same for the other verdicts, and it should be followed by the lower courts unless until it has been amended by the jurist at a higher level. So it is a long standing judgment of the Supreme Court which must be followed by lower courts, though it is erroneous. Though it is an error one, there may be some clauses which may be misrepresenting, but still, since it is issued by the Supreme Court, after careful examination of all the facts, all the lower courts, for all the lower courts, it becomes an binding. So it is on the maxim that is via trita. So the main intention here is a frequent path is a reliable path. So it's not like there should not be modifications. It's rather in this way. If a judgment is given, the judgment is probably given after careful evaluation of all the minute details, and in such a circumstance, the jurist would have carefully looked in all the ratio decidendi, all the reasons, facts, carefully evaluated, and then only he would have issued a verdict or a judgment. And such judgment should become a most reliable one. If a judge says one thing in one judgment and another thing and another judgment which is related to the same features, then it brings in inconsistency, and inconsistency is something that may not be accepted and welcomed in especially the legal world. So it is right to say a frequent path is a reliable path, because already it is established. People have walked on this and people have trust on this. So that should be the same scenario with the legal verdicts or legal judgments. If often judge-made law is changed, the transactions constructed by people based on judgment law may be collapsed. Means it becomes a trust deficit situation. People may lose trust in the legal system because they somehow feel that the legal system lacks consistency. It is not consistent, it is not same in all the situations. So in order to gain the trust, or in order to hold up the trust of the common man, generally the law or the judgments that are given should be the same in all the situations, irrespective of the social status and other things related to the victims in the case. In the past, there were no provisions for reporting the judgment, especially till the 17th century. Most of the verdicts were not recorded to the court, were not preserved, or were not documented in the court. It was in the 17th century that they felt the need for reporting the judgments to the court. And England was the first to start reporting the judgments, and it was somewhere around the 17th century they got into reporting the judgments. The Chief Justice Park explained the urgent need for recognizing the binding force of precedents in the year 1933. So, in the case of state decisis, it can be said that a desperate need was raised or was identified by Chief Justice Park, who emphasized, who gave, and who has forced or who has put it very clear that it is very much important to record all the judgments, and it came somewhere into practice after 1933. In Indian Constitution, state decisis has been recognized under the Article 141. Okay, the law declared by the Supreme Court of India shall be binding on all courts in India, including the Supreme Court of India itself. Okay, let us now look at one of a case study. In Bengal Immunity Co. Limited versus State of Bihar, All India Record 1955, Supreme Court 66. The court held that through the judgments of the Supreme Court of India or binding on the same court, there is still a freedom to depart from its previous decisions or decisions if valid reasons are recorded for doing so. Okay, if valid reasons are there, then the Supreme Court has a provision to deviate from its own previous judgments, but it most likely doesn't happen on a frequent basis. Okay, let's move on with Estoppel. The doctrine of Estoppel is dealt in sections 115 to 117 in Indian Evidence Act of 1972. So, what is an estoppel? Estoppel is a provision that prohibits a person from giving a false evidence by preventing them from making contradictory statements in the court of law. So what it basically says is, if a commitment either in the form of word or in the form of act is made in the court, so that act or that word becomes the final, and the party cannot change its stand in the later years or in the later passage of time. The main thing is to avoid contradicting of the facts. It should not happen that a person in a court has said something, a person says something before the parties, okay, in a contract, and when the contract is challenged in the court, he changes his words. So that should not be the thing in the eyes of the court. The things should remain the same, and to prevent them from making contradictory statements, the concept of estoppel has emerged in the law system. The objective is to avert the commission of fraud by one person against another. Avert means to avoid. How? So if a documentary proof is existing, then that documentary proof becomes the direct evidence. Say, for example, one person has agreed to sell his car for 1 lakh rupees to another person, and he has signed an agreement, and later on he got a better offer or a better prospect who was offering him 2 lakhs for the car. Now here the person cannot take a back step because he has already committed that he will purchase the car for 1 lakh, and he cannot change his word that now he is not willing to sell his car, or he would sell the car at 2 lakhs. Okay, so this is to basically avoid the commission of fraud against another person. Next, so it holds a person accountable for false representation made by one. So Estoppel is such a great provision that it directly holds the other person, and it doesn't allow the person to deviate or take back his words. Let us look at an example. If Mr. X is an employee of PXT company, and in court he denies not to be employee of that company, then later on he could not claim the salary and all the basic benefits emoluments from that company. Why? Because before the court he has made a statement that he doesn't belong, or he is not an employee of that company. Okay, that very statement will take away all the basic rights that are associated with the company, and he cannot change his words stating that by mistake he has said that he is not an employee, he actually works in the employee. So there is no provision, and Estoppel doesn't allow him to change his words. So what he has made the initial commitment that he is not the employee will only be taken into consideration. The further statements will be void. They will not be taken into consideration anymore before the court. Okay, so let us look at the essential conditions of Estoppel. So first one, the representation must be made by one person to another person. So unless and until a representation is not made, there is no possibility of any offer. So there should be an offer, and there should be an person receiving the offer. Then only the situation of Estoppel will arise. Second, the representation must be made must be as to the facts, not as to the law. So they should be related to the facts. Okay, they should agree with the facts, but they should not be in connection, or they should not be based on the governing laws of that particular time. The representation must be as to the existing fact. Okay, so it should not deviate. There should not be any scope of deviation in the mutual contract or mutual agreement where the two parties are getting into it, and it should be related to that current situation. It should not talk about the past or the future events. It should not refer either to the past or future events. The representation must be in a manner the other person believe it to be true. So it should not be on the premises, or it should not be made on something that really doesn't exist, or it should not be based on the things which never existed. Okay, then there is no possibility when the thing doesn't exist or such conditions don't exist, then application of Estoppel is not at all possible. Okay, so the person to whom the representation is being made must act upon the belief. So he should have it is the responsibility of both the parties to actively participate in the agreement. or in the contract, then only there will be a provision for the application of estoppel. So the person to whom the representation would be made should suffer a loss by such representation. Now, when will someone move to a court? When he had been a victim or when he had faced the loss. So the situation where someone has incurred a loss should be existing. Then only there is a possibility that the issue can be highlighted or moved to the court. Let us look at estoppel of types of estoppel. So the first one is estoppel by record or quasi record. Estoppel by record. So if someone has stated or entered into a record by putting his signature or giving his sufficient evidence in the form of a record, then there is no provision, or the law holds such a person very strongly, and apostle can be applied in such cases. Apostle by deed. Okay, so apostle by deed, this is something which is not common in Indian setup, which was very common in England or the native speakers of English. So apostle by deed is a scenario where a written agreement is made on behalf of one person acting on the other person. So when such an agreement is made, then also there is no moving back. So the agreement which was planned or which was written should be adhered to, should be taken into consideration. So apostle by conduct. So any agreement or any promise that has been made on the basis of conduct should also be fulfilled. Then if in the case of failure, it can also be a situation where apostle can be applied. So let us look at one of a case of Pratima Das versus State of Orissa. So All India record of case is related to 1975, Orissa case number 155. In this case, what happened is Pratima Das, a student, has secured admission in MBBS, and due to the delay or some other reason, the university, she had secured the admission, and due to some differences, they later informed that her admission was cancelled. She tried to get into an admission seeking BSc, into an BSc course, but unfortunately she couldn't. And later on, Pratima Das challenged the state of Orissa in the court, and here the apostle was applied, and the court said that once a seat was allotted to a student, the university or the body institution cannot move back. And in this case, Pratima Das was eligible to get the seat or secure her seat in the medical course and could do her MBBS course. Let us move on with the concept of liability. Liability, it denotes a duty of a wrongdoer to redress the person against whom a wrong is being committed. Okay, so liability, to what extent I am liable? We offer here this question or sentence statement made by people. So liability is basically the amount or the risk, okay, which I have knowingly or unknowingly committed have to be compensated, and that compensation which is done by the wrongdoer is nothing but a loyalty. So basically it denotes a duty of wrongdoer to redress the person against whom a wrong is committed. So it may be for a wrongful act or omission. Sometimes it also happens where person would have overlooked. He had no intention of not doing it, but somehow it's a human tendency, sometimes we overlook. That is nothing but omission. It is not an obligation. Obligation is something where the other person has a sort of moral binding to perform the act. So liability is not an obligation. It is an voluntary act that is being done to done the damage a person has committed knowingly or unknowingly to the other person. According to Solomon, liability is a bond of necessity that exists between the wrongdoer and the remedy for the wrong. So Solomon has made it very clear that liability is a bond of necessity. Means, so if some wrong has been done, the wrong had been committed intentionally or unintentionally, that other aspect, but wrong has been done. When some sort of wrong has been committed, so it becomes responsibility of the wrongdoer to rectify it. So that rectification is nothing but a remedy. Provide a proper solution for the wrong so that the wrong still doesn't remain a wrong anymore. Now moving on further, so we have different types of liability as civil liability, criminal or penal liability. Civil liability is a situation where a penalty may not arise. In case of civil liability, in most of the situations, things will be settled in terms of mutual understanding. In case of criminal or penal liability, there will be enforcement of law. Okay, like anything that is done against the government property. Okay, anything that is done against a life-threatening situation of a person. Okay, or anything that is done putting the other person's life in risk will bring in the territory or the under the umbrella of criminal or penal liability, remedial or penal liability. Now, this may arise in situations where things were done unintentionally, certain part of a government asset or property was damaged. So for this, the wrongdoer may openly and freely express his will to correct his mistake. Okay, and in some cases, so along with rectifying the mistake based on the severity of the problem or severity of the nature of the problem, sometimes they can also be penalties being levied by the concerned government authorities. So tortious liability. Tortious liability, as the name itself suggests, it is a wrongful liability. Now, mostly in tortious liability, the intention was not there. It was not meant to be done, but unfortunately, due to overlooking of the things, or sometimes accidentally without the intention, here intention plays a major role. the doer has no intention to do it, so it has perhaps happened unintentionally. So this sort of liability is referred as tortious liability. Okay, so in case of let us look at the case of Town Area Committee versus V. Prabhudayal, All India Record 1975, all 132. In this landmark case, one Mr. Prabhudayal has constructed a building in an encroached area or in an area that belonged to the government. So since he did not possess, or it was an encroached area, it was illegal, and the Town Area Committee had all the rights, all the liability to demolish the property, and the property was demolished, or the illegal construction that stood in the government property was demolished by the Town Area Committee. And later on, when this was moved to the court gave a verdict that the property structure itself was illegal in nature, and when it was illegal in nature, it has no ownership, then it cannot be claimed under the liability. It doesn't fall under the category of liability, or the damages cannot be claimed in such a case, as the building itself was built on illegal land, or the land which Prabhudayal had no access or no control, or he did not own the land. So the verdict was given in favor of Town Area Committee, as the land was illegal. Let us move on to the concept of obligation. Obligation in legal sense implies to one class of duties. Okay, now obligation is something where we cannot move back, but in legal sense it talks mostly of a class of duties which have to be performed at any cost. It is a proprietary right in personam. So it is not an it is not an obligation. Solomon defines obligation as vinculum juris, which means a bond of legal necessity that binds together two or more definite individuals. Example, a duty to perform a contract as agreed. Okay, like say suppose two parties, A and B, have entered into a contract to sell a piece of land. Now A has an obligation to surrender the land to B, and B is under obligation to pay the promised amount to A before he gets ownership of the land which he has recently purchased. Anderson defines obligation as a kind of control exercised by determinate persons over certain determinate persons. Like example as specific acts is a good example of to understand definition of Anderson. Now when we talk about kinds of obligation, we talk about contractual obligation. Contractual obligation, whenever there is a contract between two or more than two parties, each member of the party or each member of the each member of the contract has to oblige, has to follow, has to stand on the obligation which he has made. He has to fulfill his part. He cannot escape from or say no to the obligation, contractual obligation. So the next one is a deletical obligation, and the last one is quasi-contractual obligation. Let's move on to the rule of law. Basically, it is derived from the French phrase which says le principle de legislative, means the principle of legality. It is also referred as the principle of legality. Lord Denning stated that every person in land, no matter how powerful or high in status he may be, law will always be above them. So irrespective of the social status of a man, okay, whether the man is from a rich family or whether he is from a poor family, law doesn't differentiate. Law applies same to all, or in simple words, no one is above the law. Law holds each and every one alike, let it be in terms of punishment or in terms of reward. It remains to same to all, irrespective of caste, creed and wealth. It is basic and general principle of the Constitution. So it is the very basic and general principle on which most of other principles of the Constitution depend upon. In the words of Max Weber, legal domination as an idea of government of law rather than an idea of men. It is described as supremacy of law. Okay. According to decisis theory, rule of law has three pillars based on the concept that a government should be based on principles of law and not on men. So here Dicey highlights a very essential point, that the principles of law should be based on the circumstances, should be based on ratio decidendi, and not on the people who are involved in the case. Okay, the pillars of such an legal system should be supremacy, equality and predominance of the legal spirit. Okay, so the law should not hesitate to use its ability and capacity to ensure that the end justice is given to all the people alike. And that brings us to the end of today's session. Hope the inputs I have given will be helpful to you, and I again and again say these are all the previous year's topics which have very frequently reappeared in the previous papers. Hope the topics will be helpful to you to prepare in the process of examination preparation. All the best. Okay, stay happy, stay blessed. So please do like and share the good work. Have a good day. Thank you.